Good morning folks, Alex Woods here, financial mis-selling litigator, and I'm posting you today from the glorious surroundings of the Marriott Victoria and Albert Hotel in Manchester. And I am here for a financial mis-selling course this afternoon, and I'm here to meet my sort of counterpart solicitors who work in the same sector as I do in Manchester, who are going to be attending the course, and I'm meeting him for lunch at 12:15. So I want to, this is a spontaneous post, I haven't prepared this at all. I just really wanted to make an announcement and to celebrate what for me is probably one of the most, how can I put it, satisfying, and not, but more than satisfying. I can't find the words. More than satisfying, convincing, and one might also use a superlative like resounding victory in my paint protection litigation cases that I've been running now for 5 years, and probably the most resounding victory ever since I first started in the sector. And here it is. I'm grasping in my hands the judgment. And it's the reason for all it is such a momentous moment in the life of my career as a financial mis-selling litigator is, I mean, firstly, it heralds that the sort of the new dawn of the unfair relationships test in financial mis-selling cases. And it also is a very important stepping stone for me into the sector. I am a law firm now as of February of this year. I'm posting on the 20th of October 2014. And it also is terribly satisfying because it's a case that we never expected to win. And counsel advised us that he wasn't interested in the case insofar as he thought it had a 20% prospect of success. It's a long-running case against the old enemy, MBNA, Europe Bank Limited, with whom I've crossed blades with frequently in the past. It is satisfying because we took a real punt on the case, and we didn't just sit back and or withdraw or accept a derisory offer in settlement before the proceedings commenced, before we went to trial. That's the other thing that's about this case, is it went all the way through to a full trial. And also, I think finally the most satisfying thing about it is that I did it almost virtually pro bono. It was allocated to the small claims track. Surprisingly, we never thought it would be, and so we were unlikely to ever get paid for running this case. But nor am I going to pick up a cost bill, and I might get some of my costs paid for a quantum hearing that's going to take place in order to establish just how much money my client is entitled to. So that's by way of a preamble, and the case. I'm just going to tell you a little bit about the case itself. Essentially, the facts are these. In 1989, the client took out an Abbey card. They transferred to MBNA in 1998. They then discovered the existence of payment protection insurance on their claim in 2010, and the proceedings were commenced a good couple of years ago. Now, the very interesting key feature of this case is payment protection insurance missold on a credit card. Okay. The other side were unable to produce document to demonstrate that the client had actually ticked the box for yes. However, the reason why we were advised that it was a weak case was because counsel said the court would have two problems basically with the case and our client's testimony. Number one would be the fact that when it transferred from Abbey to MBNA, when it transferred, extra documentation was sent out, and MBNA were able to demonstrate or prove that in all probability extra documentation would have been sent out, and that there were numerous letters declaring increase in interest rates over the succeeding years, and that the client in effect acquiesced to this payment protection insurance on their credit card at the time that it transferred to MBNA. MBNA didn't like the fact that they hadn't originally stuck it on the card. It had been that they had bought this debt. They didn't like the fact that they were liable for the other side sticking the PPI on the credit card. Nevertheless, they were happy to take the PPI, and the judge referred to a particular section of the Consumer Credit Act, I won't bore you with now, that says that, you know, if you assign a debt to somebody, that person takes on the burden rather, as well as the benefit of that debt. So if a payment protection insurance product had been stuck on the card and you've allowed it to run, then you know, you're liable. However, very experienced counsel's advice was that we would have a problem with the acquiescence argument, simply because, although it might have been stuck on unlawfully, the client had clearly seen it on the face of the documentation. You know, a reasonable person would have seen the payment protection insurance and the fresh terms and conditions when they were sent to the client in 2001. But the other argument was, and this is a more important, or well, equally important, very interesting argument, and this is an argument for any consumers out there needs to be aware when it comes to thinking that they've got a huge amount of money owing to them. It's not always the case. That is the duty to mitigate. So you've got a payment protection insurance product that's run on a card since 1989. There was some dispute about that. It may have been from 1998. Still, it was a very long period of time. And of course, compound interest on credit cards has an incredible effect of increasing the quantum of the claim. So, you know, this claim was, when it was originally bought, was in the 20 grand mark. So, you know, the thing that this other problem rather is the fact that the client should have seen payment protection insurance appearing on their statements. Now, when the judge heard this case, the counsel on the other side actually gave our client quite a hammering in the witness box on the fact that doesn't she read her statements? You know, you should have read your statements. And he took her through the statements. What's that? It says payment protection insurance cover. It's there for 15 years on your statements, and you're telling us you haven't acquiesced to it, you didn't want it, and you're telling us that you couldn't have cancelled it, i.e. you should have mitigated your loss. So there's a big argument over the mitigation of the client's loss, because they should have cancelled it earlier if they really didn't want it. So for that reason, our counsel, who as reasonably conservative counsel, felt that it was a risky case to run to trial, and that we had no more than 20% chances of success. So those are the brief facts. Let me tell you what happened at the actual hearing itself. Well, the most interesting part of it, and we used, incidentally, a very junior barrister, but from a very good set of chambers, a high flyer, but a very young high flyer. And I couldn't justify expensive counsel, nor was it proportionate or appropriate for such a small claim that was on the small claims track. The other side had reasonably senior counsel, in fact, and they packed the courtroom with their own people too, and they produced an expert witness, Mr. Matthew Perrins, who gave evidence. And there were other luminaries, or reasonably senior, I don't know, solicitors. Apparently there was another solicitor and a junior assistant or solicitor. So it was a bit of a David and Goliath, because the only people we had from their side was our young high flyer in his very first trial, and my very new paralegal assistant just out of law school. So it was really interesting afternoon. I wish I'd been there, but I couldn't justify. I was just too busy. Couldn't justify the cost of going up to Milton Keynes. But the most interesting, one of the many interesting things about the case was that the judge opened his remarks when everyone arrived in his courtroom and said, you know what, I never much liked the amendment to the Consumer Credit Act when it was first brought in. And I think my counsel must have breathed a sigh of maudlin gloom and pessimism at what might then take place and what finding the judge might make. He was an old judge, and he reminded us that he was around when the original Consumer Credit Act in 1974 was enacted, and he didn't like the consumer credit legislation wrapping consumers in cotton wool and all this sort of thing, and he especially didn't like the unfair relationships test amendment. So if you take anything out of this video posting today, take away the expression, the head of claim, the unfair relationships test, section 140 of the Consumer Credit Act as amended in 2006. And what was so interesting is he went into that hearing with a negative view of the client's case, and by the afternoon, apparently our counsel made a stonking closing submission after lunch, and fortunately the judge managed to stay awake for it, and he by the end of his closing submission, it's very unfair to the judge. I'm sure he was a very respectable judge who has who doesn't have a tipple during the lunch breaks, and he doesn't have a problem staying awake in the afternoon. You will be aware, actually, recently of a judge who was severely reprimanded for falling asleep whilst a witness was giving evidence. It was in the news quite recently. Anyway, I digress. So judges do occasionally fall asleep, bless them. But anyway, he didn't fall asleep, and in fact, he so didn't fall asleep that at the conclusion of counsel's closing submissions, he remarked that he was surprised and astonished that the banks hadn't lobbied Parliament harder back in 2006 to prevent this bit of legislation getting on the statute books. And he remarked that the key and most sort of powerful part of this new legislation was a little section buried away, subsection 9, in the Consumer Credit Act 2006, section 140, that puts the burden of proving where an allegation is made, a proper allegation is made, the burden of proving that there wasn't an unfair relationship on the bank, on the credit card company. And because MBNA Europe Bank Limited hadn't been able to produce the original paperwork, the burden fell on them to prove that it hadn't been unfairly added. The client had given testimony that she never wanted it. She hammered away in cross-examination. I didn't want it, she said over and over and over again, until counsel for the defendants got a little bit narked, a bit frustrated. But she just stuck to her guns. So he remarked that he had to conclude, therefore, that she didn't want it and she wouldn't have ticked any box. And of course, we know anecdotally, but not just anecdotally from experience, that how can I put it in a diplomatic way? Credit card companies have not been unknown where sales representatives have been incentivized by performance-related pay that could as much as double their salaries. And don't take my word for it, go and check out the FCA's reviews on these issues. One might suspect that an over-enthusiastic sales representative might from time to time have slipped a little mark in the box yes, or have phoned the client at the time of activation of the card to suggest to them that they might like to have payment protection insurance on their credit card as well. So that was the judge's finding, and I think a really fair finding. But the thing is, at law, I mean, the council was quite right in a way to give this 20% prospect of success, because at law there are all sorts of problems, the problems that I've alluded to, and those problems arise out of a legal culture or legal landscape, if you like, that existed prior to the enactment of the unfair relationships test, where as claimants coming before the courts, you have to, jump through various hoops, prove various claims, meet the requirements of negligence or contract or misrepresentation. You have to, really meticulously and decisively state and lay out your claim and, tick all these boxes and jump through all these hoops in order to get a victory. And historically, defendants could just sit back and say, well, just take pot shots and then find one weak link in the chain and then you're finished. What's so interesting about this unfair relationships test is it shifts. It's a somewhat seismic shift in the legal landscape. And now it says, no, you, Mr. Defendant, must demonstrate where a substantive allegation has been made. And please note that in this case, the client had described how with her mortgage she had taken out payment protection insurance, and she had actually claimed when she had an injury at work on payment protection insurance on another loan, and she explained how that had been a far more comprehensive selling exercise. And I think and she said, if I was claiming on that insurance, why on earth wasn't I claiming on the MBNA insurance at the time I had this accident as well, in respect of the MBNA credit card repayments? And the obvious answer is because I didn't know it existed on the card. Okay, I'm sorry, I didn't check my statements in meticulous detail. Not everybody does. So by putting together a substantive allegation, not a flimsy one, note, the burden has shifted, and the defendant now finds themselves having to jump through hoops and having, and they're not getting as easy a ride. This is why I think the courtroom was somewhat packed, and the poor judge was somewhat suffocated by representatives of the credit card company in question. So there we are. I'm not going to post this just yet because there is now another hearing being listed. I'll just read you the findings of the judge. I'll just read this out to you just to nail the point. He found, upon hearing counsel for the claimant and counsel for the defendant and hearing the evidence and reading the documents in the bundle, it is declared, pursuant to Section 140A, Consumer Credit Act 1974, that the relationship between the claimant and defendant was unfair, and it is ordered that all sums paid by the claimant to the defendant as payment protection insurance premiums on account number blah 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 be refunded to the claimant. Accounts be taken, this is the interesting point, we're going to have fun at a quantum hearing now, accounts be taken so that the precise cost of the payment protection insurance in that account may be ascertained. Damages to be assessed and a date to be fixed, time estimate 2 hours. Liberty to apply for further directions. Even though, because it's on the small claims court, we're not going to get paid for this, there's a possibility we may be able to convince the judge at the next hearing that actually the credit card company's conduct has been unreasonable. There's no way the client could have brought this case herself, and particularly at the quantum hearing we should have the costs of that hearing. So thank you very much. I'm leaving it there for the moment, and as I'm just now about to embark on a financial mis-selling course, we as solicitors have to jump through hoops each year in order to gather and collect as many continuing professional development points as we can in order to prove that we're worthy legal professionals. I'm signing off now from within the quite impressive and munificent surroundings of the Marriott Victoria and Albert Hotel in Manchester. Wooden beams, warehouse conversion, beautiful old building. I am signing off for now, and do keep your eyes peeled if that's the correct expression, for the next posting, the follow-up posting on this case, Campbell and MBNA Europe Bank PLC, because that hearing will deal with the issue of just how much money our client is entitled to by way of refund. Goodbye for now.